first as a Black woman and then as a defense attorney.
You care about
cross section because there's an obvious group of people, that distinct group that is missing.
That language that you should be using, because that's what the law says.
Currently, because of the overwhelming media coverage, any potential juror may have already formed an opinion about the case.
Members of the jury, welcome to this evening's Jury Duty Unmasked. My name is Will Snowden. I'm the director of the Juror Project, and it is a privilege to be with you all this evening. The deputy director, Portia Chiffon, won't be joining us this evening, but we are excited to have her next month on our Jury Duty Unmasked. So what's tonight's topic? If you haven't been paying attention, there's been a lot of conversations as it relates to the power of grand juries. So what we're going to be doing this evening is we're going to be having conversations about what's been happening in Washington, D.C., and what the people of Washington, D.C. that have been serving as grand jurors have been signaling to the federal government. We're going to then discuss more generally and more broadly what it is that grand juries do and how they differ from petit juries or trial juries. And then lastly, we are going to have a call to action as it relates to your role in making sure that we are creating a justice system that is worthy of that name. So what's been happening in Washington, D.C.? You may have heard this old phrase that says prosecutors can indict a ham sandwich. And when I first saw the video of the man who threw a sandwich at the law enforcement that was present in Washington, D.C., I immediately thought of that phrase. And as my colleague student said, you can indict a ham sandwich, but apparently you cannot indict the man who threw one. Now, this phrase, you can indict a ham sandwich, what does that mean? It's essentially suggesting that when prosecutors seek indictments, 9 times out of 10, they're going to get it, right? That it is very easy to indict somebody, that you can even indict a ham sandwich. But in Washington, D.C., we have seen this increase of military presence, of federal law enforcement presence in Washington, D.C., underneath this umbrella of promoting public safety. Before we get into grand juries, let's talk about public safety and what promotes it and what doesn't. Some of you might know I live in New Orleans, Louisiana. Louisiana has had the highest incarceration rate in the country for many, many, many decades. We have used the tool of incarceration to try and facilitate public safety. But let Louisiana be the case study that demonstrates that incarceration alone does not promote public safety. Because if it did, we'd be the safest place in the country, but we're not. Sometimes I talk about our criminal legal system as the catch basin for the failures of other systems. So when our access to quality education fails as a system, people will be directed towards the criminal legal system. When our access to quality housing fails, or when our access to jobs fail, when we have those system failures, people are going to be directed to have more contact with the criminal legal system. If we could imagine that every arrest is an indicator of some system failure, we could then try to approach conversations about the root causes of criminal behavior, but thinking more critically and more intentionally about what are the things that we need to be investing in, which are 9 times out of 10 people for their abilities to thrive, as opposed to increasing the presence of law enforcement in search of a problem that does not exist. With that said, the deployment of federal troops to Washington, D.C. has occupied many of the attention of our different news channels. And what we heard from members in Washington, D.C., of people in Washington, D.C., and the community in Washington, D.C., is that crime is actually going down. So why are we having this increase of military presence underneath the disguise of public safety when whatever tactics that have been deployed in previous months and in previous years has already created a downward trend of public safety or a downward trend of crime? Now, with that aside, when we have seen people in Washington, D.C. protest the presence of this increased law enforcement, we've been seeing people arrested. And there are two people who have been indicted, whose indictments were sought for charged with essentially felony assault on a law enforcement officer. The first person I want to talk about is this man that we saw throw a sandwich at some police officers. And he was doing so while he was kind of previously yelling at them that he didn't want those officers in the DC community. And when I've had conversations with many of the folks that I know in Washington, D.C., none of them have talked about wanting that type of military presence in their city, and nor do they believe that it's actually going to promote public safety. But the man who threw the sandwich was charged with felony assault on a police officer. And that case was presented to a grand jury. And the grand jury was assembled of people from the Washington, D.C. area. And after the prosecutor presented their case, that grand jury voted not to indict. Now, remember, there are two ways in which people can be charged with a crime in the United States of America. One way is via what is called a bill of information. There are some charges in our country, at least within state court, that prosecutors can initiate solely by filing a bill of information, which is the official charging document accusing somebody of a crime. The second way in which people can be charged with crimes is called a bill of indictment. So when somebody is indicted, that means that a grand jury voted to indict that person. But with this man who threw the sandwich, he was not indicted. There's another case I want to talk to you about. And this relates to a woman also in Washington, D.C., who was alleged to have interfered with the transfer of custody of two people that were being brought to the custody of ICE. The allegation suggests that she took out her phone to video record the transfer of custody of those two individuals and then placed herself between herself and one of those individuals and an ICE officer, and she was ordered to leave and get out of the way. They said that she didn't comply. A scuffle then ensued, and then they arrested her. She ultimately is charged with felony assault on a federal officer for the scuffle that took place. The prosecutor presents these facts to a grand jury, and for the first time, they vote not to indict her. For the second time, they vote not to indict her. And then for the third time, they also vote not to indict her. So one, I want to just demonstrate the power that we are seeing of members of the grand jury voting not to indict, and the signal that is representing as a form of resistance to the government deploying these federal soldiers and these federal officers to cities where they may not necessarily be welcome. But I want to talk about seeking an indictment 3 times over. That's an unusual practice. And when we looked at some data from the Bureau of Justice Statistics, and they looked at how many indictments the Department of Justice has sought over the years, what we found was that out of roughly 200,000 indictments from a report from 2016, that only 6 indictments were not returned, meaning that almost every time those prosecutors sought an indictment against a person, the grand jury voted to indict. They voted to charge the person with a crime. But here in Washington, D.C., this grand jury voted 3 times not to indict, and it was 3 different grand juries. Now let's talk about why that is concerning. Traditionally, the process for a grand jury is members of the community are going to be summoned the same way you get summoned for a trial jury. And you typically are on a list to be summoned if you're registered to vote, or if you have an active driver's license, or if your jurisdiction uses other lists like child support payor list or child support payee list or utility bills. We've seen a variety of lists that are used. If you're on one of those lists, you get a summons in the mail and you show up to court, and you're informed, or perhaps to the DA's office, if it's for grand jury service, you'll be informed of the duration in which you need to serve on that grand jury. Now, how does a grand jury work? Well, we will have a group of people sitting in the DA's office in a grand jury room, and they'll be in kind of like a grand jury box. The prosecutor then comes in, and they will call witnesses to the stand, and they'll ask questions of those witnesses to elicit information for the grand jurors to listen to. And as the grand jurors are listening, they're trying to decide whether or not there is enough information that has been presented to vote to indict the person who's being charged with the crime. Now, the threshold to indict is just probable cause. In America, we have different standards in our criminal legal system. We have reasonable and articulable suspicion, which is sufficient justification for an officer to stop somebody and ask them questions. And if they think that they're armed and dangerous, they can also do a pat-down frisk. So we have reasonable and articulable suspicion. We then have probable cause. We then have proof beyond a reasonable doubt. So probable cause is a standard. I hate it when people say it's such a low standard. It is a standard, and there is a burden that needs to be met. And so what ends up happening is in the grand jury, the prosecutor has to present enough information of evidence that's elicited from those witnesses to demonstrate to the grand jurors that there's probable cause here to charge this person with a crime. Now, when we see grand juries vote not to indict somebody, they can do so for one of two reasons. One reason is the prosecutor simply has not presented enough evidence for there to be sufficient probable cause to charge the person. That doesn't happen that often. The second reason a person might not indict is because they disagree with the charges that are being levied against the person. And that's what we've been seeing in Washington, D.C., where these people who've been demonstrating some resistance or protest to the increased presence of law enforcement, they've been voting not to indict these individuals. So the woman who is charged with felony assault on an officer, prosecutor presents it to a grand jury once. That grand jury says, we're not going to indict. They leave. They then impanel a second jury, same result. Third grand jury, same result. But this is what's concerning. A senior official with the Department of Justice, his name is Akash M. Singh, has instructed his prosecutors that if you are seeking an indictment and the grand jury does not return an indictment, impanel a whole new grand jury and try again. Now, in the grand jury system, we don't have a principle of double jeopardy. And double jeopardy stands for the premise that a person cannot have their liberty put in jeopardy twice when they're accused of a crime. And so that means if you go to trial and you're charged with theft from a store and a jury finds you not guilty of that crime, the prosecutor can't come and try to charge you again with that exact same crime. That's considered double jeopardy. We don't have that as it relates to seeking indictments. But this practice of trying to increase the chances of seeking an indictment offends the notions and the principles of double jeopardy. What I think would be more proper is if we had a court rule that said prosecutors cannot seek additional indictments unless they have some new evidence to present to the grand jury. Because if you're just trying over and over and over again, you're essentially forum shopping. Now, in the legal world, we use that term forum shopping to describe when a litigant or a lawyer or somebody who's trying to bring a case wants to identify the best judge or the best jurisdiction to file that case with, increasing the likelihood and the chances that that person would seek a favorable outcome or receive a favorable outcome. So in grand jury, in Washington, D.C., what we've been seeing from these grand juries is a form of resistance. And they're saying, we do not agree with the utilization of law enforcement in this way. And the people that have been protesting the presence of increased law enforcement and the fact that they're being charged with crimes is not something that is consistent with our values. So while these grand jurors have been serving on grand juries, they've been voting not to indict. I have a question that I've received. What does this mean for people who are potential jurors? Is it likely that they will start saying jury decisions can be disregarded, or is this just on the grand jury level? So for potential jurors, what this means is when you serve on a grand jury, know that you have power to vote what is called a no true bill, which means a no true bill of indictment, or said more plainly, you have the power to vote not to indict a person. And if you don't indict somebody, if a person is not indicted, then there are no charges, there is no case, and there would be no trial. So we have two different types of juries in America. We have the grand jury, which is much larger. In the federal system, it's about 16 to 23 people. And all they're deciding is whether or not to charge somebody with a crime. Grand juries start cases. Trial juries or petit juries finish cases. So at the beginning of a case can start because a grand jury voted to indict somebody. And then at the end of the case, a petit jury will decide whether or not to vote guilty or not guilty, deciding whether or not that person is going to be convicted of a crime. So as potential jurors, you need to be aware of the power that you have in both of those juries. One of the powers that you have on the grand jury is to vote no true bill or to vote not to indict. If you think that there has been probable cause or you agree with the behavior that's being criminalized and the charges being levied against the conduct that is alleged to have taken place, you can also vote to indict the person if you so please. At the tail end of the case, you have two options. You can vote guilty or you can vote not guilty. You can vote guilty for the top charge or you can vote guilty for a lesser charge. You can vote not guilty if you believe that the prosecution simply hasn't met their burden of proof beyond a reasonable doubt. Or you can vote not guilty under the premise of jury nullification. And remember, we've talked about the power of jury nullification before. It stands for this premise that jurors have the power to vote not guilty for somebody who might be factually guilty. And we think about why somebody would do that. Well, sometimes people do not believe in the punishment that is being levied against the person for that particular crime, so they vote not guilty. Sometimes people don't believe in the behavior that is being criminalized, so they vote not guilty. We need to understand that there's so much power in this jury box that in this moment of our country right now, where we are seeing grand juries and petit juries fulfill the idea of the framers of the Constitution that they had in mind as jurors being this last line of defense against a government who was abusing its people. Right? During the origination of the Constitution, the drafting of the Constitution, we talk about the framers really loving the right to jury duty. They call it the right, so we call it the right, so nice they named it twice. And what that means is that in the United States Constitution, they ensured the right to access a jury in two different sections of our Constitution. It is in the original Article 3, Section 2, and it's also in the Sixth Amendment to the Constitution. When the framers of the Constitution were trying to figure out how do we establish the power of the people, they wanted to make sure that the community could access the power that exists in that jury box. What we have heard is that there are potential indications that federal troops or National Guard might be sent to other cities. I've heard conversations about Baltimore potentially, or Chicago, or New Orleans, where I live. And what we want you all to know is that there are different ways in which you can resist this aggression by the federal government. If you think that this is an abuse of power, or if you think that they come into your city and they're just arresting people to justify their presence, and you get a summons in the mail, that summons could be for grand jury service. That summons could be for serving on a petit jury or a trial jury. Understand the power that exists in that jury box, both for trial and for the grand jury. So what we want you to keep in mind is to understand that this is the moment we need people to be very creative with how we can resist in a lawful way the efforts that have been administered in terms of sending law enforcement in increased numbers to cities underneath this disguise of trying to promote public safety. We know that incarceration, we know that the tools of policing and prosecution and prisons cannot be our only attempt to try to promote public safety. And quite frankly, we as American people deserve so much more effort to think about how we can promote public safety that does not rely on old and stale and, quite frankly, tactics that have proven not to work to promote public safety. We've gone so far afield of this idea of accountability. Accountability has to incorporate this premise of repairing harm. You know, when you have conversations with communities that practice restorative justice, there's something that is universally acknowledged. In those communities, they first acknowledge that there is an existence of a community. And when a person has committed harm against that community, it is up to the community to articulate what that person needs to do to repair that harm. So I sometimes use this example in class. This is a hypothetical. I want you to imagine that I have a group of students in a classroom, and I walk up to a student and I kick them in their leg pretty hard, right? It hurts their leg. I have now violated some trust of the community. And I've created some harm, not only against an individual community member, but also harm against the community at large, because I violated an implicit understanding of safety that we exist peacefully amongst each other. Restorative justice talks about how do we position the community to articulate what the person, me, needs to do to repair that harm. And the first person that we could consult is the person who I kicked. And we could ask them, what do I need to do to repair the harm that I've committed against you? And they could offer and suggest a variety of things. They could say, you need to go get me some ice. You need to apologize. You need to let me kick you in your leg, right? So there are different things that the person could articulate that from their perspective believe I need to do to repair harm. But then also the community can be part of that conversation. Perhaps the community is saying you need to go get anger management classes, or you need to go to jail, or you need to pay a fine, right? There's this idea of incorporating the community's conversation of what needs to be done to repair harm. But what we see with the deployment of more police or more law enforcement to our cities, it is completely disregarding the conversations or the needs or the ideas or the desires of the community that is there. I haven't come across people in Washington, D.C. who have been saying, we want more law enforcement. We want more police presence in order to promote safety. And I think since we haven't seen that type of call to action, then the voice of the people is really pronouncing itself with these votes on the grand jury not to indict people. A question that I've received is how many people are on the grand jury? So in the federal system, it's 16 to 23, and the state systems largely mirror that as well. A unique thing about grand juries is that you do not have to have a unanimous decision. You simply have to have a majority, right? So and 16 is typically the quorum. So if there are 18 people on the grand jury or 20 people on the grand jury and 16 vote to indict or 16 vote not to indict, then that is going to carry the vote of the grand jury. We've talked about this concept of unanimity before. In Louisiana, we had non-unanimous juries. Oregon also had non-unanimous juries. And non-unanimous juries in Louisiana originated out of some very racist practices. We know that an individual by the name of Thomas Semmes is on record at the 1898 Louisiana Constitutional Convention saying the purpose of this convention is to promote the supremacy of the white race. We know a product of that convention, and if we use his words, not mine, a product of that white supremacist convention is non-unanimous jury verdicts. And what non-unanimous jury verdicts meant, at least at the time in 1898, is that there were 9 people who could vote guilty and 3 people could vote not guilty, and the 9 would carry the verdict to convict a person. They were very clear in terms of why they wanted to have this non-unanimous scheme, and it fulfilled 2 main goals. One, the delegates at that constitutional convention knew that Black people were going to start to be able to serve on juries. And if they were going to be serving on juries, they wanted to first nullify the Black vote. And then second, they also wanted to continue this ability to more easily convict Black people to feed this convict leasing system that was very popular in Louisiana. We changed from 9 to 3 to 10 to 2 in 1974. What we know from the Innocence Project of New Orleans is that there's been at least 13 people who have been exonerated who were originally convicted via non-unanimous verdicts in Louisiana. And what that means is that there was at least 1 or 2 people who voted not guilty, but since we did not require unanimity, those people were unable to prevent an innocent person from going to prison. So now on the trial side for trial juries, unanimous verdicts are required across the country. In grand juries, you do not have to have a unanimous agreement. It is simply a majority of the people that are present, and the quorum is typically 16, that votes to indict or votes not to indict. Another question, where do grand jurors come from? Well, the same lists that are used to summon jurors to serve on a trial are the same lists that are used to serve on a grand jury, to summon people to serve on a grand jury. Now, in the federal system, you will have different districts. So I'm in Louisiana. We have in New Orleans, it's the Eastern District of Louisiana. When I lived in New York and when I worked in New York and Manhattan, that's the Southern District of New York or the Eastern District of New York. Or the Central District of whatever state, right? So states are typically, from a judicial district perspective, carved out with different judicial districts. And the structure of our court system is we have district courts, appellate courts, and then the United States Supreme Court in the federal system. So grand jurors are summoned from the counties or the parishes that make up that judicial district. And it's typically going to be more than one county because the district is going to be large, but it could potentially be one county. But the grand jurors come from the jurisdiction of that district court. So in Louisiana, in the Eastern District of Louisiana, we have Orleans Parish, St. Tammany Parish, St. Bernard Parish, St. John the Baptist, St. James, I think Ascension Parish. We have a lot of different parishes that are coming together that are going to be serving as a representative sample of that jurisdiction to serve on the grand jury, or if there are actual trials, they would also serve on the trial jury. So that's how many people you have on grand juries, 16 to 23. As it relates to petit juries or trial juries, typically you're going to have 6 or 12, and then you have alternates. The role of alternates includes to listen to the entirety of the trial and essentially be backup in case one of the jurors gets sick. And if nobody gets sick, then the grand jurors get to go home, but they stay throughout the entirety of the case. If a juror gets sick, instead of having to restart the whole trial over, the alternate will get popped in and the trial will be able to continue, and they'll still be able to deliberate with the required amount of people serving on the jury. Another question I have is, why is the evidence threshold so low or non-existent in grand jury indictment hearings? Well, the threshold is probable cause. In the United States, we have the Fourth Amendment, which protects our liberties and protects the government from searching our property or searching our persons or seizing our property or seizing us as individuals. It creates this right to protect us against those types of searches and seizures unless probable cause has been established in front of a judge for a magistrate court to sign a warrant essentially for our arrest. In the grand jury system, the threshold is only probable cause because this is only the start of a case. And so to balance out the role of a person's liberty and the sanctity of that liberty and the position of the government to prosecute people potentially for crimes, the decided threshold is going to be probable cause to go out and arrest a person if they are in fact indicted on a particular crime. It's not going to be as high as proof beyond a reasonable doubt because that is the threshold that we have for trials. So probable cause is kind of the middle ground. Now, I wouldn't describe it as a super low bar. What I would describe as our understanding of what probable cause is supposed to look like has been misinterpreted. I have argued in front of judges for no probable cause, and in good faith have demonstrated why there should not be probable cause. But sometimes there is a deference that is offered to prosecutors when they bring cases. And I worry that sometimes in the grand jury room, where you have everyday citizens, everyday people who are listening to the prosecution, they understand that, okay, this person is a professional. This is the job that they do. And we're just kind of here to make sure that they're doing their job in a fair way. And it looks fair to me because they just called all these witnesses who said that the defendant did X, Y, and Z. But guess who's lacking from that grand jury room? The defense. There's no defense attorney. The person who is accused of a crime is not present. So grand jurors are only hearing one side of the case. Now imagine if the defense would be able to be present in a grand jury and they'd be able to say, okay, the defendant said X, the witnesses said X, Y, and Z, but now we want to call our client, or now we want to call these witnesses to rebut that. That'd be a different story. But that is not what is required at a grand jury. That's more like a trial. That's what a trial is for. But it's important to know that the likelihood of getting an indictment is so high because grand jurors are only seeing one side of the case, and there's an implicit deference or trust for prosecutors and the witnesses that they present in the grand jury, who are typically going to be law enforcement, that the information that they are providing is fair, accurate, and true. But if we had both sides, there might be a difference to the likelihood of being able to secure an indictment. The next question I have is that, is there a requirement of the grand jury composition to be diverse, to be a jury of your peers? I love this question. So there is the Sixth Amendment establishes this right that we know as a person has a right to have a jury of their peers, or a fair and impartial jury is actually the language that we pull out from the Sixth Amendment. The Supreme Court has said an essential component of that Sixth Amendment right to a fair and impartial jury is to have your jury selected from a fair cross-section. And that applies at every stage of the case, right? So for the grand jury, that grand jury needs to be selected from a fair cross-section, the same way your trial jury or your petit jury needs to be selected from a fair cross-section of the community. Now, there is not a particular requirement or a right to have a particular person on your jury, but you do have a right to select your jury from a fair cross-section or a representative sample of your community. Now, here's where a lot of our work with the Juror Project comes in. We believe that the current legal tests that are in place to assess whether or not a person has been provided a fair cross-section is insufficient, right? It requires essentially the defense to prove that there is a distinctive group that's missing from the jury panel and that the underrepresentation is due to some systematic exclusion. And it's really hard to prove systematic exclusion. Let me give you an example. In New Orleans, we're roughly 53% female, 47% male. And let's say I'm representing somebody going to trial, and the jury comes in, and the jury panel is 80% women. So I know that there's an underrepresentation of men. I would bring what's called a fair cross-section challenge. I'm challenging the makeup of this jury or the veneer panel, and I'm saying there are some men that are missing. Orleans Parish looks different than what this panel looks like. In order for me to basically win that challenge, I have to prove that we have underrepresentation of men because of some systematic exclusion. There's something about the design of how the system is summoning jurors or getting people to come to the courtroom that is excluding men. And if I can't prove that, then my fair cross-section challenge is likely not going to be granted. So there is not a requirement for our grand juries to look a particular way or to have a particular composition. There's a case called Holland versus Illinois, where Justice Rehnquist clarifies from his perspective that the Sixth Amendment does not demand a particular person on the jury, but they only have to, the right only applies to having the jury selected from a fair cross-section. So if we're thinking about composition requirements, we can make the argument that applies to the pool of people from which the grand jurors are selected from, but not to who is actually seated in the grand jury. Now, there is no jury selection when it comes to grand jury service. You just simply get a summons in the mail, and then boom, you're going to be on a grand jury. Now, obviously, if you have scheduling conflicts, you might be able to postpone your jury service. But in the trial jury, in the petit jury, you go through a jury selection, and it's technically a deselection because you are being asked questions and you're giving answers, and then the attorneys are deciding whether or not to keep you on the jury, which means just do nothing, or if they want to remove you from the jury, they can use what's called a strike against you. I have another question. It says, it plays out to the prosecution advantage because it's their play park. 100%. Imagine if I invited you over to my house and I show you all the ingredients that I'm putting in this gumbo, and I'm telling you how good it is, and I just give you a very, very small sample of the smoked sausage, and you're like, this is good. Boom, we're going to indict. It's not the best example, but you're exactly right. We are in the prosecutor's environment, and they are telling us how beautiful the curtains are. They're telling us how beautiful the carpet is, and they're asking the members of the grand jury to say, hey, don't you think this is a beautiful house? So there is an advantage here. There is not representation from the defense during the grand jury process when prosecutors trying to seek indictments. And why is that a good thing? I want to look at the other side, right? We know that if we created a grand jury presentment or seeking a grand jury or seeking an indictment, if we allowed it to be an adversarial process, it would turn into a mini trial. And from an efficiency perspective or from a judicial resources perspective, there will be other folks who say, this is how it's supposed to work. Because we're not talking about taking away someone's liberty. We're simply talking about formally charging them with a crime. They will still have available to them the resources to defend themselves against these charges. And if they can't afford an attorney, the government will provide one for them. And so some folks would argue that probable cause is an appropriate threshold, and the fact that the defense is not present is okay, because we're not talking about incarcerating somebody. We're only talking about indicting somebody. Another question, how can defense challenge that the grand jury when they are excluded from those proceedings? Great question. So grand jury proceedings are, for the most part, kind of sealed and confidential. You don't, in rare instances, would you be able to get information about the testimony that was elicited during a grand jury proceeding. But what you can do is you can file what's called a Freedom of Information Act request or a FOIA request, asking for the demographic information as it relates to race and gender for the people who were summoned for grand jury service. And then you can attack the representation of that pool from which the grand jurors were pulled from. So that's the only way in which you could challenge essentially the grand jury, by demonstrating that it is not representative of the community, or at least the lists that were used or the process that was used to summon those jurors is not consistent with this right to have access to a fair cross-section from which the grand jury is supposed to be pulled from, and ultimately your trial jury is supposed to be selected from. What other questions do you have? I've been really encouraged to see how people have been flexing power in the grand jury room. And I want you all to think about the power that exists in that jury box. If you get a summons in the mail, we have consistently been talking about how we want you to show up for jury service and the importance of and the power of your presence in that jury box. And we want to remind you that that power is still equally important when it comes to serving on a grand jury. The main takeaway I want you to have, there's a few main takeaways. One is understanding that a grand jury is all about whether or not somebody is going to be charged with a crime. And if you believe that a person should not be charged with a crime, or you believe perhaps that there are other motivations behind their arrest, you can vote not to indict a person. You have that power. On the tail end of the case, when the case is going to trial, we want you to be present in that jury box so that you can represent the power of the community and be part of those conversations of whether or not you believe the person should be found guilty or not guilty of a crime. Unfortunately, what we have seen over the history of our country is both an intentional and sometimes unintentional practice of excluding Black people from our juries, of excluding women from our juries, of excluding other people of color from our juries. And if we want to have some faith, or if we want to have some trust, or if we want to even have the optics of integrity with our criminal legal system, it's really important that every member of our community has equal access to the power of the jury box. So with that, when you get that next summons in the mail, I hope you're not only excited to serve, but you also know the power that exists both within the trial jury box as well as the grand jury box. Because in the grand jury box, you can vote not to indict, or you can vote for a no true bill if you are so moved. You don't necessarily have to become a rubber stamp for the prosecution asking you to indict somebody. And of course, in a trial jury or a petit jury, the power of your presence in deciding whether or not you think you should be voting guilty for somebody is going to help fulfill our quest to create a justice system that is worthy of its name. My name is Will Snowden. This is the Juror Project. Thank you so much for joining us with this Jury Duty Unmasked. One more question that's coming in. Is the prosecution required to give defense testimony from the grand jury of the witness that possibly points to the innocence of the person accused of the crime? When prosecutors are in possession of evidence that suggests an individual's innocence, that's typically called Brady material, or giglio. Like there's a couple of cases that create this requirement on prosecutors to turn over evidence or information or documents that's in their custody that is going to be used to prove the person has committed the crime or potentially proves the person did not commit the crime. My gut says that if evidence has been presented during the grand jury that suggests innocence, actually, I don't know the answer. It's a good question. This is where I would tap in the Deputy Director, Portia Chaffon. My gut says that you might have to go through another hurdle to be able to prove or to access that information, because there's a general consensus or there's a general desire to keep grand jury proceedings under seal and confidential. But it's a good question about whether or not you'd have to turn over testimony from a grand jury that potentially could lead to evidence or represent evidence of a person's innocence. For our new viewers this evening, thank you so much for joining us. We hope that you can continue to tune into the work of the Juror Project. We are trying to increase the diversity of our jury panels. We're trying to improve people's perspectives of jury duty. And ultimately, we want to make sure that the community understands the power of the jury box, both in the grand jury and for the petit jury or the trial jury. Please share our posts. Please invite your folks to join our Substack. We do these Jury Duty Unmasked the second Wednesday of every month. We'll be doing another one in October. I hope you all can join. This evening we want to make sure everybody's understanding the power of the grand jury, especially in a time where we are seeing more charges being brought that are really just not appropriate for the conduct that is being alleged. But we're also seeing this demonstrations of people voting not to indict as an act of resistance. The framers of our Constitution knew very, very well that it is the people of this country that will serve as the last line of defense from a government that is trying to abuse its people. And you have the power to resist a tyrannical government. You have the power to resist an abusive government, particularly when that abuse is coming in the form of prosecutions that should not be approved of. So thank you for tuning in this evening. I hope you tune in next month. Follow us on Instagram and all of our other social platforms if you aren't already. And that there's so much power that we want you to be mindful that you have. One last comment came in that I have to acknowledge. A member of my family recently served on a jury, and I was so thankful and proud of their service, particularly because it was a challenging case. And that's a whole nother conversation maybe we can explore in October. Our Deputy Director, Portia Chaffon, is not only an attorney, but she's also a social worker. And I hope that we can explore with her what some of the resources we should be providing jurors who serve on cases that have very traumatic experiences in terms of the allegations or the facts that they are being exposed to, the types of images that they might have to view, and the exposure to the natures of sometimes very violent crimes where people are being accused of very serious things. Jurors can't just turn off a light switch after seeing and receiving all of that information. There was a New York Times article at the end of last month, I believe, that talked about the different types of resources we need to be providing for our members of the jury to ensure that any type of secondary trauma that they might experience from their jury service is being appropriately addressed. we want our members of the community to serve on our juries. And we have to acknowledge that sometimes jurors are going to need resources and support after a case is done so that they can fully process and perhaps recover from some of the secondary trauma that they have been exposed to through their jury service. So thank you so much for tuning in, and thank you for my family members for serving on that jury for a very difficult case. And I'm going to wish you all a good night, and I'll see you next time.